Number 18, People v. Regan.
Good afternoon, Your Honors. My name is Matthew Hugg. I represent the appellant Andrew Regan. I request 2 minutes for rebuttal.
Okay, Mr. Hugg, thank you.
Your Honors, this case provides an opportunity to restructure the Taranovich factors with respect to Singer. I think very clearly there is a Singer violation in this case. I think it's unavoidable. I think that the dissenting opinion of the appellate division, as well as most of the decision by Judge Richards in the trial court, amply demonstrates that if this doesn't constitute a Singer violation, then we're operating under a new standard. There's a 4-year delay. The people acknowledge that this delay is excessive. That leads us to the excuse for the delay, for which
How
they...
does the impact of the defendant, it's pre-indictment delay?
Yes.
And he's free at the time.
Right.
How does all of that come into play?
Well, that's the fifth factor under Taranovich, which is prejudice, which I think you got to keep in mind, Your Honor, that prejudice, when there is an unexcused prolonged delay, is, as this court has stated, and the Third Department, is the element of least significance. It's presumed.
So during the time that this 4-year delay was going on, were they able to document what they were doing during that time? And I'll ask a double question, were they doing something throughout that time, or were there periods where nothing was occurring?
There were, to say that there were gaps between when things happened is to really stretch the definition of things happened. So the complaint is made on August 9th, 2009. I would add, just to jump off, that this case has spanned 3 decades. All right? We are here in the normal course of a criminal case, conviction, appeal. That is part of the reason for Singer. This person has been in prison, has been under the cloud of this thing for going on for a 3rd decade. To answer what was happening, well, nothing was happening. From August of 2009, they interviewed the complainant, they interviewed the defendant, and they obtained the results from the same
When they interviewed her, she immediately said what had happened. She was cooperative. She submitted to an exam, and her boyfriend offered DNA, correct?
Yes. I'll do you one better, Judge. On that date, they had all the evidence, and only evidence, that they present at trial. So 4.5, 5 years later, they're only using that which they obtained on August 9th, 2009.
Well, plus the DNA of the defendant they obtained later.
Right. So they established that the defendant, the complainant's boyfriend, and third John Doe's DNA was present on the sample. So I take your point. There was one other piece of evidence that they could have gotten way earlier, and so that's what they hung their hat on was, well, we didn't really know how to do an
But
A-Bay
unlike
motion.
in some cases, they had identity. They knew who the defendant was at that point
Right.
also.
Exactly. There was really, the DNA piece did not establish much of anything other than to establish that the defendant wasn't truthful in his initial statement to the police. So
I thought they asserted that part of the delay is due to the defendant's unwillingness to provide a sample.
no. That to the extent that makes its way into the record, it is untrue. So to jump off Judge Troutman's point, which is what activity was taking place, I'll lay that out for you. In April of 2010, all right, this is almost a year after the complaint, Investigator Duffy of the New York State Police asked Mr. Regan's then attorney, will Mr. Regan consent to a buccal swab? There's no response. They wait for 14 months and do nothing. They can't point to a single thing that was done. 14 months go by, and a different investigator, the prosecutor, ADA Nissen, on June 26, 2011, says to the same attorney, hey, will your guy submit to a buccal swab? The case is so old by then, and the emails are in the record, the case is so old by then that the attorney says, what year was this from? I don't really remember. I'm certainly not representing him anymore.
Well, Mr. Hugg, the legislature has decided that There is no statute of limitations on a rape case. They're saying for public policy, it could be 10 years, it could be 20 years that a woman could come in and say, and make a report.
Yes.
So are you saying that the 4-year delay here, like, are we in essence putting on a statute of limitations by declaring pre-indictment, not even pre-indictment, pre-accusatory instrument, right?
Well, that is, I'm glad you asked that question, because that is a fallacy raised by the prosecution. Singer is a check on the statute of limitations.
Okay, but Singer also implied some kind of misconduct, right? Singer, the people there were looking for an advantage, and they said, we're not going to do anything because we'll wait so we can get the statements we need. There was some misfeasance there. There was something going on which they were doing to gain a benefit that is not going on here. Maybe here it was ineptness, incompetence. I don't know what it was, but it wasn't to gain a strategic trial advantage like Singer. You
Well,
disagree with that?
Yes, I do. I do disagree. I don't think that we need to demonstrate bad faith.
I'm not suggesting that you do. I'm just trying to distinguish Singer.
Did the people obtain a benefit by delay? Yes. Look at Mr. Plumadere's testimony, riddled with, I don't remember, I can't recall, I don't know, I don't remember. So Singer is a check on the statute of limitations because we do not want to do one of two things. We do not want to encourage police departments to sit on their hands for a prosecutorial advantage. We also want to move cases along so that the public can be sure that if the police have enough to charge or do something, they'll do something. They won't just sit there and say, oh, you know what, there's no statute of limitations. We'll get to that, we'll get to that, we'll get to that, while the public is exposed to a potentially dangerous person.
So then in this case, would the rule of Regan be that in these types of felonies that don't have statutes of limitations attached to them, 47 months is the outer limit for pre-indictment or pre-accusatory delay?
30 months?
47, I think that's the total number of months.
That's the total here, but the cases that are cited in my brief show that far less time is required.
So there's nothing new here, this,
Nothing new at all. And to suggest that the statute of limitations should be somehow a bar to the use of Singer would unravel decades of precedent and would expose defendants and the public to endless cases. I mean,
Well, you're not saying a complainant couldn't come forward 10 years later, and that's when the DA learns about it for the first time, and...
Right.
Right.
that's why we have a
And-
statute of limitations,
and
so
you're-
in that
and you're
situation,
not-
that could
I
happen.
guess, I mean, I count there as being something pretty close to 2 years where the people haven't offered not a word about what was going on. You're not saying that if they had a colorable explanation for that time, this case wouldn't come out differently.
Well, that's part two of the Taranovich factors. What is the people's excuse for not proceeding more promptly? They have a 14-month gap and a 16-and-a-half-month gap and a 4-month gap where
But I guess,
absolutely
let
nothing.
me put it a different way. You're not saying categorically that a 4-year delay means a speedy trial violation no matter what the circumstances.
Correct, I am not saying that. I'm saying that there are cases that are legion that say that if the people are trying to investigate a thorny matter, which is what Category 3 provides, which I would ask the court to eliminate because it creates confusion. There's no need for Category 3 of the Taranovich factors because it's necessarily assumed to be as part of Category 2, which is the reason or the excuse for the people's delay. A complicated case merits and should be afforded wider latitude for an investigation.
What's your view of the rape in the first degree with respect to being a complicated case?
I mean, any case could be complicated, Your Honor. In this case, the case isn't complicated.
But it's a first-degree rape case. Unfortunately, we all know there's been a terrible history about prosecutions and victims in these cases coming forward and being subject to mistreatment in the system. So doesn't that complicate a complainant case like this, where you have somebody coming forward and saying, they were assaulted in this way, and now we have to get DNA because we have a witness coming forward in this type of way, and that DNA, for whatever reason here, is delayed, but it doesn't go to the nature of the crime. I mean, it seems to me like you're saying this is a very simple and uncomplicated investigation.
Yes, I do. I am saying that. If you look at the trial evidence, Judge, it's basically defendant says this, the complainant says this, and the DNA says that. There is nothing...
Serious crime nonetheless.
Right. Right, it is a serious crime, but in Taranovich, this court specifically said that Category 3 is not a check-the-box type of category where you just say, oh, serious offense, we're going to forgive a lot of delay. What it says is, and it really, I think it was just an attempt to make this a more complicated analysis than it had to be. The prosecution can show that they engaged in reasonable due diligence over the course of, say, 4 years because this was a complicated case. They have not said that. In fact, there's been 3 judges that have dispensed with their excuse altogether, and yet those same 3 judges also said because of the seriousness of the offense, that cuts in favor of the people, and that there is a contradiction there, that if they can't raise an excuse as to why it took them so long, which they can't, try as they might, and they've changed their arguments since they were initially in front of Judge Richards after the appellate division majority invented, oh, the case was ongoing and it was open. Those are not excuses. The permitted excuses, according to this court in Lesiuk, L-E-S-I-U-K, are a need to investigate to discover the offender, elimination of unfounded charges, and to gather sufficient evidence to charge. Those are not excuses raised by the people, nor could they be because they don't exist in this case.
Thank you, Mr. Hug.
May it please the court, Matthew L. Peabody, Assistant District Attorney, St. Lawrence County, on behalf of the respondent. With respect to the 4-year delay here, I think that what's important is to analyze it looking at some of the cases that have been cited with respect to, these timeframes less than ours, People v. Staley, People v. White, People v. Winfrey. I think those are all situations.
What was going on?
Well, there was, in those cases, nothing, no activity whatsoever.
In this case, the problem here, in this case that is of concern, is that there was a victim. She was fully cooperative. She came forward. She submitted to an intrusive exam, and her boyfriend consented to buccal swabbing and giving his DNA. A name was given. Why no prosecution?
Well, you have to counter that with the other available evidence at that time, too, which is that suspect consented to an interview with law enforcement and adamantly denied having any sexual contact at all. So at that point...
So the prosecution didn't go forward because he denied it?
Well, at that point in the investigation, you're weighing the balancing of the evidence you have, which is you have a complainant's statement about what happened on this night, and you have the suspect completely saying not at all.
There are a number of rape cases tried throughout this country where there is no DNA. There is exactly what you just said.
No, correct, but in this situation, we balance the fact that we have 2 completely conflicting events, not I had contact with her and it was consensual, there was no contact at all.
So the record...
We now have we know that we're awaiting the results of a SANE kit.
The record reflects that on November 10th, 2010, the Assistant District Attorney spoke with the New York Prosecutors Training Institute about how to get the defendant's DNA, and it's 2 years later, November 9th, 2012, when they actually apply for a warrant.
That's correct.
That seems really hard to explain or even believe.
Judge, I don't believe that there's anything in the record to support an excuse as to why it took so long for the people to make that application, but
Well, presumably
reversely,
it's
there's
not
nothing
even...
to show that it was done in bad faith.
Well, presumably it's not, well, do we need bad faith? mean,
I think so when we're analyzing this.
The constitutional speedy trial right depends on bad faith?
No, I think when we're analyzing factor number 2, I think one of the things that Singer and Lussick make clear is that you need to look at whether the decision to defer was in good faith or bad faith. I think that Barker v.
Well, but that presumes it's a decision. I mean, this doesn't even look like a decision. It looks like, I mean, I assume, I don't know, but I assume that when the ADA called the Training Institute and said, how do I do this? They weren't told, we don't know. They were told, here's how you do it. And there's a form for it, right?
Right. But following that, there's attempts to obtain the sample voluntarily. And I would interpret those as, that's products of negotiation and leveraging.
And when the attempt was made to obtain the sample voluntarily, the response from counsel was, hasn't Singer already killed this? Wasn't it
Well,
something like
that's
that?
that's the second attempt. The first attempts are made in April of 2010, I believe.
That's a pretty provocative statement. I'm just thinking that would have sped you up a lot, I would think. But it doesn't seem to have done so here.
Well, actually, I think it does, Judge. I think that conversation takes place in June of 2012. The DAs and state police apply for their search warrant
4 months,
five
4
months
yeah.
later.
That's a long wait, isn't it? Especially when defense counsel has told you there's a Singer problem here. And by the way, I don't even remember this guy. It's been so long.
Right. No, the additional 5 months certainly doesn't help our arguments, but I think, again, when you're looking at the excuse for the delay, you can contrast it with cases where there's no excuse at all. Basically, we put the file in a box and forgot about it for years.
But isn't that what it looks like here?
No, I think the record is complete with a lot of examples of activity that take place on this case. Now, the main example has been this need to obtain the defendant's sample as a comparison, and they focused on, well, that shouldn't have taken 3 years to do. But there's other things that are taking place on the case while those timeframes are ongoing. State police are investigating and interviewing.
I'm looking, for example, at I think it's 88 Botts' affidavit, which is what's submitted in opposition to the speedy trial motion. And I see absolutely nothing to explain the 16 months from June 10th, 2011 to October 18th, 2012. Not a peep about what happened there. I mean, that to me looks like sitting in a box.
For those 4 months, I would...
16 months.
June 2012 to...
June 10th, 2011.
Oh, if you refer to the record, Judge, at, I believe it's the Respondent's Appendix 9 and 10, in January 2011, in February 2011, June 1st, 2011.
Yeah, no, I'm asking about from June 10th, 2011 to October 18th, 2012.
I apologize, Judge. In between those two time frames, after following the interview of Mr. Woodward, there's the June 26 correspondence between our office and Attorney Pulaski regarding a voluntary DNA sample. On October 11th, and then the investigation gets reassigned to a new investigator who then meets with the DA's office subsequently after that. So between June 10th, 2011 and October 18th, 2012, those are really the only two activities supportable by the record in terms of what was happening on the case. But I think still you need to look at that excuse for the delay and consider, I think one of the things that this court's referenced Barker v. Wingo before, and I think the defendant has cited it in his papers.
So can I ask you again, what is the excuse for the delay?
I think the excuse for the delay was the need to obtain the defendant's DNA sample as a whole.
That 4 years, that's what the problem was?
Well, 3 years to obtain the sample, and then following that, I think the people worked very quickly to secure an indictment. The defendant's DNA sample was obtained in November of 2012. So, if we're looking at the time from incident to obtaining the DNA sample, it's 3 years, and then...
But then you have another quite long period of time, maybe a year or so, waiting for the lab to come back with a sample? With the results, I mean?
I think it's, the record, as I know it, Judge, I believe it's at Respondent's Appendix 3 and 16. I believe the search warrant is applied for November 9th, 2012. The defendant consents and comes in to give his sample November 12th in response to that order, and then the results from the lab are received in February 2013, so approximately 3 months till February. Okay. Following that, the delay from, he's arrested subsequently, very shortly after that, approximately 9 days later. The delay from there till indictment is basically the negotiation between the parties that kind of encapsulates one of the other issues.
How do you
So
balance that?
let's say that the court determines that the excuse provided is simply not acceptable. It is not an excuse. Okay. Does that mean then the Taranowic factors do weigh in favor of the defendant, or is there something else that we're missing?
No, Judge, I think that's, I think what you need to focus on is that excuse. And even if it's not a valid excuse, I think you can look at it three ways, like the court in Barker v. Wingo did. They basically said you need to look at the excuse for delay in three ways. Was it done in a deliberate attempt to delay, like bad faith, like we had in Singer? Or was it done for a completely good faith reason, like the need to do further investigation? Or is it somewhere in the middle,
So
a
is-
neutral reason?
Is
Like
your answer to Judge Rivera's question that the other four Taranovich factors just don't factor in?
No, I think they do factor in, but I think you need to look at the delay first and consider it like, it's basically a neutral light, right? We're not, if you're going to assume hypothetically, like, we don't find good cause for your delay, well, there's certainly nothing in the record to support that it was done in bad faith either. So it's
Well, if you're
it's kind of
dragging your
neutral.
feet, why isn't that bad faith?
I'm sorry.
Let's say the record reveals that it's not prioritized, there's action is at a snail's pace when it happens. Why wouldn't that be bad faith? This is
'Cause there's nothing
This
that
is the
peop-
work of law enforcement.
There's nothing
Dragging
that-
your feet, not doing it, ending up, as counsel has argued, with a situation where a witness, at least one witness, the memories fade, makes it a difficult case, both for the defense and the prosecutor, yes, but certainly for the defense. I mean, why? I understand the difference, yes, of course, between good and bad faith, but it does really push the envelope about what we're really working to prosecute the case when this is the action that the record reveals. It's not that I'm looking at the record in any jaded way, it's just what the record shows.
No, I completely agree, Judge, but I think the reason you need to look at it that way is because there's nothing that people gained advantage by that. There wasn't like they were purposely seeking to delay this defendant's day in court or seeking to give this victim justice.
How does the delay balance against a greater policy of prosecuting and holding people accountable for rapes in the first degree?
Well, I think there, Judge, that I think we're back to, that's where I think the analysis of the fact that this is a crime that the legislature has given an unlimited statute of limitations on. You know, we're talking about 4 years, and we've conceded that is a substantial delay. There's no ifs, ands, or buts about that. But taking in the greater context of a rape first, where you have two parties with completely different testimony about what occurred on that event, and a need to get more definitive evidence to move forward, not saying we couldn't have moved forward, but to be most successful, to give that victim, you know, the best success for justice, you know, it was chosen to delay to get the defendant's DNA. And whether or not that delay was reasonable or unreasonable, I don't think is the analysis. I think we need to focus on whether it was bad faith or good faith.
Thank you.
Good faith, bad faith isn't one of the Taranovich factors. To the extent that it should be considered, I remind this court of what it said about good faith. This court mentioned good faith in association with the Taranovich factors, but it was, quote, good faith to defer commencement of a prosecution for further investigation or for other sufficient reasons. It's not, oh, we're going to gather up in the back room and, grind our hands and say, oh, we'll wait until this guy has no chance of winning.
But regardless of whatever reason is given, one of the factors is the seriousness of the case.
Right, but that must be read in conjunction with the reason for the excuse. You're giving, in other words,
Must
the way that you read factor 3 can only be, we will give additional leeway in a serious case because it takes longer to investigate. Not, it isn't, that factor doesn't exist as a check the box to say, oh, serious case, let's let them
Wait
sit
a
on their
minute,
hands for
couldn't-
longer.
I'm sorry, couldn't it have two different purposes? One that you just articulated, but also there's a greater societal interest in prosecuting crimes that are more serious, and so we're going to read the guarantee a little bit laxer in those circumstances.
Well, that suggests that when the legislature passes a statute of limitations, as it seems to be.
No, it has nothing to do with the statute of limitations.
Right, but it's the same basic argument that what are we saying? We want the police to be lackadaisical in serious cases because they have unlimited time, and we're not going to hold their feet to the fire?
But it could be saying we just want serious crimes to get prosecuted.
No doubt, but that is covered in Part 2 as to why is it taking so long? Well, Judge, it was a serious case. We had a complexity. So seriousness doesn't only mean the penal law offense definition, but the seriousness of the offense could be a forgery.
But to Judge Wilson's point, couldn't the test and that prong also be factoring in the victim and the impact on society, this particular victim? This is a first-degree rape case, and we're going to balance that. Not only that it's complicated, it necessarily would take you longer. To me, yes, that's somewhat subsumed in your excuse. So on the theory that it isn't subsumed in that, why isn't it that factor encompass that effect on the victim, on society?
Right.
On this crime going unpunished because of delay by a prosecutor?
Because I think that's the gray area, Judge, when you say, well, we're going to ascribe a different set of rules because we don't want this type of crime to, quote, go unpunished. There's reasons why we have these rules.
We do that. I mean, as you said, the statute of limitations does that.
The statute of limitations does that so that in Judge Wilson's example from earlier, that if the victim comes forward after having not said anything and the police don't know anything about the case, that case could be prosecuted. In this case...
The only reason, right?
What's that?
That's not
It's the
only
main reason, right? I mean, sometimes the police are aware of a crime but have no idea who the identity is if they come upon a body that's been buried in a shallow grave, yes. But that's not the case of what Singer's trying to do.
That could be check-kiting, too. I mean, it doesn't, the complicated nature of the case doesn't always go to the seriousness of the case. And I think the point here is that factor, in terms of seriousness, goes to impact.
Well, I guess we will agree to disagree, because when I read the factors that Taranovich has laid out and its explanation in it as to what that factor means, and it's quoted in my brief, it doesn't have anything to do with a categorical penal law offense. And I would note that with respect
to the seriousness and the impact, you have a victim that's completely cooperative. We don't want vigilante justice.
Right.
So we do want them to have the opportunity to have their day in court also.
And from that point of view, Judge, that is why the delay here is quite egregious, because what the people said in their position is the reason they waited is because the victim said it happened and the defendant said it didn't happen. But that isn't a reason to sit on your hands. In fact, it would have been a better fact scenario
The delay also gave the victim the opportunity to have her day in court, didn't it?
It did it. I mean, eventually. I mean, but that's the issue.
If we did it your way, that wouldn't have happened.
Well, if the police had acted and done anything over the course of 4 years, there would have been swift justice, and perhaps the defendant would have had a fair trial within an appropriate amount of time. The point that I was trying to make with respect to the dichotomy the people were raising, that their fact pattern for their argument would be better if the defendant said, yes, we had sex, it was consensual, and she said, no, it was unconsensual, that would create a situation where you might want to sit and wait and think about it and try and develop more evidence for your case. But in a case where it happened or it didn't, and there is an objective way to tell, any prosecutor worth their weight in salt would be, I'm going to go get that guy's DNA and I'm going to find out whether or not he's lying about having had contact with that person.
Thank you.
So because,
Oh, I'm sorry. Go ahead, Judge.
so because the prosecutor is not on the ball, the victim doesn't have her day in court? I mean, that's where I'm fundamentally having a hard time wrapping my head around this. Taranovich says, look at the seriousness of the crime. We have homicide cases that we've upheld 14, 15 years later, right?
Under what? Under Singer?
Under Singer. So I don't understand how a 4-year period on a rape one, where there is no prejudice to the defendant, it's pre-accusatory instrument, that you're so emphatically saying.
Well, the defendant has a due process right, Judge. I mean,
I understand that.
and
I
so
understand that.
either you say that Singer is no longer the law of the state, or you uphold it. I mean, there is no middle ground here. I mean, this is a perfect case of unexcused, admittedly excessive delay that all of us agree, I believe, was completely without excuse. And so when you look at Singer, Taranovich, and the rest, they all say that prejudice becomes the least important factor when there is unexcused prolonged delay, for which that is conceded here. So I don't see the point of engaging on whether or not this is serious. I acknowledge rape in a vacuum is a serious crime, but that is not going to rescue the people from sitting on their hands and doing nothing for years while everyone, including this defendant, sits now in a jail cell, 14 years later. There has to be an end to it. And the people are completely in control as to how this all functions. And it is the court's obligation under Singer to tell them, we're not going to permit this kind of foot dragging endlessly so that justice is forever delayed.
Thank you.